We need to open the waiting room and start the recording.
That's fine. Good. Thank you.
Chair Fiscum, we are good to start this morning.
Thank you very much. Good morning, all, and welcome to this special meeting of the Oregon Government Ethics Commission on March 1, 2025. At about 9:30 a.m., I hereby call this meeting officially to order, and as you know by now, this meeting will deal with a training regime for one of our still relatively new responsibilities, handling complaints about requirements in law for government organizations to conduct meetings in accord with Oregon's public meetings law. You may remember that the bill that gave us this responsibility, House Bill 2805, was passed in the 2023 legislative session. It is now ORS 192.610 through 192.705. And I will just add quickly that this bill passed through the hard work by Representative Nathan Sosa, a former Oregon Government Ethics Commission member and chair, and still our friend. So for the record regarding attendance this morning, my name is Dave Fiscum, and I currently am privileged to serve as chair of the commission, and I am online for this meeting. Others, Vice Chair Shanoa Payne is online. Commissioner Dan Mason is online. Commissioner Elisa McCauley is online. Commissioner Ivan Resendez Gutierrez is online. Commissioner Rick Burke is online. And I will add that our friend Commissioner Jonathan Thompson is excused today because he has already participated in this training. It's also important.
Sorry, Chair Fiscum, could I simply correct that Commissioner Burke is not online?
I apologize. Thank you very much. It's also important to note that we have a new commissioner online this morning, Ann Mettler, who has been appointed by Senate Republicans to join us. So welcome, Commissioner Mettler, and you may find out that sometimes you'll have a new first name, Commissioner. I understand that you'll also be able to attend our next regular meeting on March 7th. So I suggest that we wait for that occasion for you to introduce yourself more completely to us. But thanks for being with us this morning, and we're glad to have you join our ranks, which brings us to 8 of 9 commissioners on task. So we do have a quorum. For what that's worth, though no action is intended to be taken today. Appropriate commission staff, led by our executive director, Susan Myers, are in the Salem OGEC offices. With that, I will turn to her to describe how this special meeting will proceed today. And I just want to add a quick thank you to all of you for being willing to devote part of your Saturday to this important purpose, which will help us down the road as we deal with public meetings issues. That said, Director Myers, please proceed.
Thank you, Chair Fiscum, Commissioners. I welcome everyone to this special meeting, and as he indicated, the purpose of this is for a public meetings law training for our commission. And so for that reason, I will turn this over to our curriculum and training coordinator, Stephanie Hefner.
Good morning, Chair, Vice Chair, and Commissioners. Thank you for joining us this morning. Today, I have a version of our public meetings law training that we have developed for public officials, governing body members such as yourselves. But there are a little bit of differences to this one. So there will be points where I might point something out specifically for you all that are specific to you. And there will be other times where I may include something that you already know, but it is so that you are aware of what other governing body members are getting through the course of the training. And as you know, at the Oregon Government Ethics Commission, education is our highest priority. So trainings like this are really crucial to us being able to fulfill our mission. Today's training is while it is contains lots of the information that is in our training that meets the training requirement for governing body members that are required to get the training, this does not meet that qualification. We won't be doing polling today. There are some things that we will not be covering. So this is, if someone is viewing this, you're welcome to view it. Folks, it will be on our website, but it will not meet the training requirement that is in the ORS 1927.700. So I know that most of you know our jurisdiction, but I'm sharing this screen specifically because Commissioner Thompson, when he took the training, he gave us some very specific feedback that we've incorporated it into this slide. So I do want to just touch on this slide very briefly. As you know, our Oregon government ethics law is what we are named after. It was passed, Oregon government ethics law was passed in 1974 by Oregon voters during the Watergate era. It was a time of mistrust of government across the nation, and there was this we were part of this big movement. And we were given jurisdiction over Oregon government ethics law at that time, which looks at folks' financial connections in the community and brings transparency to those. In addition, at that time, we were given lobby law, which is contained in ORS Chapter 171. It was also a relatively more recent law. It had been enacted the year prior. And then most recently, public meetings law. Now, it's important to point out that public meetings law was actually passed in 1973. No one had jurisdiction over it until the 90s, when we were given jurisdiction over just the executive session provisions. And it wasn't until 2023, as Chair Fiscom pointed out, that the legislature gave us jurisdiction over the rest of public meetings law. So normally for our training, we do kind of go over our goals for the training. We do some pre-testing so that we can get data for our key performance measures. We will be skipping those big pieces today. So it's a little disjointed, I do apologize. But we're gonna go ahead and dive into the accountability part and talk about who's responsible for public meetings law, the actual what's happening in a public meeting. And ultimately, it is the individual governing body members who are responsible for ensuring public meetings law is followed during a public meeting, before, during, and after a public meeting. And this is regardless of whether the governing body members have staff, such as those folks sitting in the room, to help provide that support. So we have lots of governing bodies across the state that do have staff that do help provide some functions of public meetings. But we also have a lot of governing bodies across the state that don't have that staff. And ultimately, regardless of who is doing the tasks, it is the governing body members themselves that are going to be held responsible. And they're ultimately, you all are ultimately responsible for both your actions and your non-actions. And you might say, well, Stephanie, we get actions, we understand that part, but what do you mean by non-actions? And basically, non-actions is sitting silently by. You can't say, well, I didn't notice that there was an error in the meeting notice, or you didn't speak up when executive session, the conversation in an executive session veered off topic. So just not speaking up, not saying something is not grounds for being held responsible. So you are still responsible, even if you're not taking an action. We also want to point out that when we receive a public meetings law complaint, we open cases on each individual governing body member. And the commission decides whether or not there are individual violations, and fines are assessed and penalties are assessed to each individual person. And public monies cannot be used to pay any fines that the governing or that our commission puts into place. So there are a lot of thoughts about what is part of public meetings and what is not part of public meetings. So hopefully we'll clear up some of those today. But one thing that we really want people to walk away from this training is what resources are available to them to understand whether or not they're in compliance with public meetings law. As I said before, folks didn't have a lot of resources. There wasn't an agency that had jurisdiction over this. So we really want to make sure people are aware of the resources that are available to them, because there's no way they're going to walk away from this training being an expert. The biggest part of this training is the definitions. I'm going to give you a heads up. We're going to spend a lot of time walking through those definitions. It is the crux of our training this morning. We'll also take a look at the public attendance and location requirements for public meetings. We'll look at accommodations and accessibility requirements, those noticing requirements. We'll look at recordings and minutes of meetings. We will take a break and then we'll dive into the executive session provisions. So what is an executive session? What are some of the constraints of it? We'll do a deep dive into those executive session provisions. We'll discuss the grievance process as well. And we'll talk about the enforcement piece, which I know you all are aware of, but I think it's good for you to hear what we're sharing with other governing body members. And the last part, the training requirement. Funny, I always forget that button. And that's the one that I'm responsible for. So to get us started with resources, our website, which is www.oregon.gov/OGEC, is a great resource. We have a whole section on our website dedicated to public meetings law. There is a link to resource. There are links to resources here. There are links to the rules, to the statutes. So great resource to start with, as well as the training section, which is where folks can sign up for live webinars on public meetings law that do qualify for the training requirement. They can request in-person or hybrid trainings for their public bodies. And then we also keep links to all of our training resources. Becky, in your meeting materials this week, you were provided with those resources that we share with folks after the training that are also posted on our website. So I will point to a few of those as we go along, but I also encourage you to take a look at those resources. Myself and predominantly our trainer Lex Tingy have spent a lot of time developing those resources to help folks break down the law into more digestible chunks. And then lastly, I just want to point out that folks can reach out to us for advice, of course, over the phone, email. You can also submit a request for advice through our website. So all of those are available to folks. Which brings me to the next resource that we want to point out, which is our agency. So our staff as well as the commission. So we provide advice and guidance through trainings, through staff advice, staff opinions, and then of course, commission advisory opinions. With each level of advice comes a different level of like safe harbor protection. So as long as folks are following the recommendations that are set forth in the advice and the facts and circumstances that were presented to us to provide that advice are in alignment with what's going on. There is some protection there. And so, obviously some of these provide more protection than others. There's also a longer timeline involved, but we really, really want folks to reach out to us and use us for a resource and not be afraid that because we are also the enforcing entity that they can't reach out to us. This is our biggest sales pitch right here. And there's some gremlins in there. The other thing I want to point out is the Oregon Administrative Rules for Public Meetings Law contained in Chapter 199. That's where all of our Oregon Government Ethics Commission's administrative rules are located. So these were the first we adopted or published our administrative rules in October of last year. First administrative rules to address public meetings law, help provide some clarification and additional guidance. Those are located in Division 50. And then I do want to point out that just above that, Division 40 are the executive session administrative rules, which we had in place before this. And there were some changes in this last administrative rule process. There are times where I'm going to specifically point out things in the administrative rules, especially because while the Attorney General's Public Records and Meetings Manual was updated last year and is an amazing resource, I encourage all of you to utilize it, keep it bookmarked. This does not include, they were in the finalizing process of this edition when we published our administrative rules. So this does not reflect any of the administrative rules. So there are points in the training that I will highlight the administrative rule that may not be reflected in the AG's manual. Okay, so now that we've gotten through resources, we're going to kind of dive into the definitions, which I did mention is going to be the bulk of the training today. And we're really trying to answer the question. We hear it, we base this on questions that we get a lot, and that's when do we need to hold a meeting? So the answer can be very clear for some governing bodies and less clear for others. But before we can answer that question, when do we need to hold a public meeting? We do need to dive into those statutory definitions. So we're going to start with the definition of a meeting, which the statutes define as the convening of a governing body of a public body for which a quorum is required to make a decision or to deliberate towards a decision on any matter. So we're going to break down this definition and dive into each of these specific words further. So let's start with public body. So a public body is any state, regional, council, county, city, or district, or any municipal or public corporation. So a public body can include an agency of those bodies. It can also include a board or a department, a commission, a council, bureaus, committees, subcommittees, even advisory groups. So the gauge of whether an entity is a public body is whether it was created by or pursuant the state constitution, a statute, an administrative rules, an order, an intergovernmental agreement, a bylaw, or another official act. Now, I do want to point out that a single public official, such as the governor, is not a public body for the purposes of public meetings law. So that brings us to what is a governing body. So a governing body means two or more members of a public body who have the authority to make decisions for or recommendations to a public body on policy or administration. A department headed by an individual public official, that would not be considered a governing body. So we're going to take a look at the types of bodies that have authority to make decisions or recommendations to that public body on policy or administration. So there are two types. We have decision-making bodies and we have advisory bodies. So both have a role, again, on a public body's policies or administration. So decision-making bodies are bodies with the authority to make decisions for the public body on policies, or administration, as I've said before. It meets the standard of a decision-making authority, if it's a decision-making authority, includes the power to exercise governmental power and act on behalf of the public body. So examples of this include city councils, county commissions, planning commissions, school boards, state boards and commissions, fire district boards. Those are all some examples of decision-making bodies in our state. Now, advisory bodies are formed by the public or governing body for the purpose of providing recommendations on policy or administration. So governing bodies and public bodies need to be aware that when they form bodies like committees or subcommittees for the purpose of providing recommendations back to that public body or that governing body, then they are creating a whole separate governing body. And this has caused a lot of confusion about who does public meetings law apply to. So each of these governing bodies, so these subcommittees or committees, would be subject to public meetings law. So the three things that identify an advisory body are that the individuals are being appointed by the public body or the governing body. The purpose of that body is to make recommendations, and those recommendations are being made by the group or by a vote, some kind of consensus. So these look like things like budget committees, advisory committees, ad hoc committees, school district site councils. Those are some examples of advisory bodies that we see often. So there are some bodies that are not considered governing bodies. And the first is fact-gathering bodies. Now, bodies with only the authority to gather and provide purely factual information to a public body that do not have the authority to make a decision or recommendation would be considered a fact-gathering body. But it is important to note that when choosing what facts to present, you could be making a recommendation. So for example, if you only presented facts to say this site does not meet our needs, then that could be a recommendation. So because this is often a hard line to identify, if folks are unsure if their body qualifies as a fact-gathering body, we really encourage them to reach out to OGEC for some additional advice. Now, the second one is advising bodies who are advising individual public officials. So these are bodies appointed by an individual public official, and they have the authority to make recommendations only to that individual public official. And that individual has the authority to act on the public body's recommendations and is not required to pass along those recommendations on unchanged to the public body or a governing body. Okay, so let's take a look at quorum. So a quorum is a minimum number of members of a governing body that are required to transact business. So many governing bodies have policies or bylaws or directives that state how many members are required for a quorum. So for example, our commission has 9 commissioner seats, and we have a rule that states a quorum of our governing body is 5 commissioners. Now for us, this is regardless of how many commission seats or positions are currently vacant. And this is also regardless of how many commissioners are present at the meeting. Our quorum is 5, regardless. Now, in the absence of a policy or other directive, a simple majority of the governing body would be considered a quorum. So, for example, for a city with 10 members on its council, a simple majority or a quorum would be 6. So that brings us to convening. And before we dive into convening, there are some other definitions that we need to bring in, which is communication, which is the expressing or transmitting of information to another person. And this can be done through verbal, nonverbal, such as thumbs up, thumbs down, sign language, gestures. It can be done through written means or electronic means. So again, expressing or transmitting information to another person through one of these means. Now, in 2023, with the adoption of the new legislation, there was a new definition included, and that is convening. And convening can look like a lot of different ways our governing bodies come together to gather and to communicate with each other. So the first is they can gather in a physical location. The next is they can use electronic video or telephone technology to communicate among governing bodies members in real time, like we are today. You can use serial written electronic communication among members. And you can use an intermediary to communicate among members. Now, not all of these are allowed in, in public meetings law. So serial communications and intermediaries, we're going to talk about a little bit more. So serial communications is when a series of communications of any kind, so either directly or through intermediaries, are used outside a meeting conducted in compliance with public meetings law. So this can include in-person conversations, telephone conversations, video conferencing, written communications, and that includes emails, texts, social media posts. I just got a call about that one yesterday. It can be using intermediaries, which we will dive into more in a moment, or any other means of convening information. So ultimately, a quorum of a governing body members cannot use serial communications to deliberate or decide on any matter. All communications used to deliberate or decide on matters need to be during a meeting that is in compliance with public meetings law. So let me give an example of the social media one, because that's a hot topic that we get questions about a lot. So say Commissioner Fiscum is friends on a social media channel with other commissioners, and Chair Fiscum posts something about public meetings law on his personal social media account. And it's something he feels really strongly about this thing. Commissioner Payne, she gives it a thumbs up. And Commissioner McCauley gives it a thumbs down. And Commissioner Mason writes a comment in opposition. And Commissioner Mettler writes a comment in favor of whatever Chair Fiscum has said. I think at this point we've hit 5. Yes?
Yeah.
I've singled out 5 of you. So now we have a quorum, and you're having a series of communications outside a regular meeting, even though it is in Chair Fiscum's personal social media account. So it is really easy for conversations that start without a quorum to end up having a quorum. So another example is, and Chair Fiscum, I'll be with you in just a second. Another example is our county commissioners. A lot of counties only have 3 commissioners, right? So if 2 commissioners stop at the water cooler or the coffee pot in the morning and start talking about something that's going to come before them to deliberate on, then they have a serial communication. Chair Fiscum, you have a question or a comment?
Yeah, thank you, Director Hefner. First of all, I think I want to wait till the right moment for questions and comments, except I just want to emphasize on this serial one that I have been, I would add innocently, a potential violator of this, even I didn't know I was, when I simply had a phone conversation with another commissioner. The ripple effect of that could exist, and it is only in that regard that I want to emphasize this to my colleagues. This is a fairly new thing, if you will. Am I right, Director Hefner? Didn't this arise just a year or so ago? Serial communication? And
I'll let the
Myers?
real director speak.
I like giving Stephanie a promotion. It isn't actually new. The law that happened in 2023, yes, it put it into the statute, but that was based on a court decision that serial communications would have been prohibited anyway. So it's not a new idea in terms of this is prohibited by public meetings law. But yes, in 2023, the changes to public meetings law made that clearer in the statutes.
So I just want to build on what Commissioner or Chair Fiscum was getting to, and that is the use of intermediaries. So an intermediary is a person who is used to facilitate communications among members of a governing body about a matter subject to decision or deliberation by the governing body. So the term intermediary can include a member of the governing body, but it could also be a staff member, or so it doesn't have to be just a commissioner or a governing body member. The other thing to know about this is if it is a staff member that is the intermediary, the staff member isn't going to be the person held responsible. It is going to be the governing body members that are held responsible that participated in that serial communication. So this is one of those times where it can get really easy because someone, say I'm serving on a board and my colleague Casey is as well, and I go and have a conversation with her and I say, this conversation is just between the two of us. But then Casey starts thinking about it more and wants to run some ideas by Susan, and then calls to Susan, pretending the four of us at this table are on a board. And so she starts talking to Susan. I don't know that now we have a serial communication, but Casey is acting in the role of an intermediary. So it can be really easy for these situations to occur. Commissioner Payne, thank you for your patience.
Thank you. I have a question about the social media example that you gave, and maybe I'm veering off topic here, but I have concerns regarding the free speech rights of public individuals acting in their individual capacity. So the example you gave was Chair Fiscum on his personal page made a statement and then a bunch of other individuals commented on it. Are we considering, or do we have any sort of guidance from the Attorney General or anybody else about communications from individuals acting in their individual capacity, and whether we consider, is it our role to consider whether they're exercising their free speech rights under Article 1, Section 8 of the Oregon Constitution?
So it is not our role to sort of interpret or construe or make a determination as to their free speech, their constitutional free speech rights. The difference, I think, is it's not that in this scenario that Chair Fiscum couldn't post whatever he wants on his social media account and have all of you respond to it. The distinction is in the content that is being posted, that if what you're talking about is a matter such that you as governing body members can and should be communicating in a public meeting, meaning this is something subject to the commission's decision or deliberation. That is when those conversations need to occur in the public meeting, not in an outside private meeting or in serial communications. So I guess your question is, if the matter being discussed is subject to the commission's jurisdiction, is a matter that is part of your decision or deliberation, does the Article 1 free speech rights mean that you can't discuss it in private? And what the public meetings law says is a quorum of that governing body can't discuss matters relating to their decision or deliberation in private meetings, including private communications. But I think your question in terms of Article 1 is worth pursuing. I just don't know that it's a question we either as staff or as the commission could answer. I think that is a question that would have to go to the Attorney General.
Right. And I think I thought that there had been an opinion from the Court of Appeals or the Supreme Court regarding this body that said we couldn't, that we couldn't penalize individuals for exercising their free speech rights, but I guess I may need to go back and look at that. So, and I know I'm veering off topic here, but just something to think about regarding social media, because I think that's probably where that's going to come up. So thank you for letting me, go off topic here, but it's just something that I was thinking about as we're talking about social media communications. But I understand the issue as to the quorum and violating public meetings laws. Thank you.
And so yesterday, Commissioner Payne, the advice that I gave over the phone was that anyone can post whatever they want, but they do have to be cautious that how people interact with that post can then become a serial meeting. And, some social media channels allow you to turn off reactions and comments, and some don't. So just things to think through. Definitely. Thank you for bringing that up. So we've already talked about decision and deliberation. The problem with all of these definitions is you all have bits and pieces of them in each other. So it's hard to do this in a linear way, but let's take a look at decisions. So the statute's quite specific about the actions, matters subject to action, and who is taking those actions for it to be considered a decision. In order to conduct the business of a governing body, a vote of a quorum of the governing body is required to take an action, determination, vote, or final disposition. And this action is on a matter that is a motion, order, proposal, measure, ordinance, or resolution. This is what makes up a decision. Now, the decision-making process is the process that the governing body is engaging in order to make that decision. So this includes identifying or selecting the nature of the decision to be made. So figuring out what types of decisions need to be made, gathering information that's related to the decision to be made, identifying and assessing alternatives, weighing or considering information, and then lastly, making a decision. So it can look, the decision-making process doesn't need to include all of these. It could be, a few, it could be all, or it could be one or two. Which then brings us to deliberate. So deliberation means the discussion or communication that is part of the decision-making process. And when we say discussion, that means the consideration or debate of the matter. And remember from earlier that communications can be verbal, they can be nonverbal, they can be written or electronic. So now that we know what makes up a meeting, let's look at the different types of meetings. So public meetings law applies to the following types of meetings. So it applies to regular meetings, such as the meeting we will have next week on Friday. It applies to special meetings, such as our meeting today. Emergency meetings, which are called in response to an actual emergency. We'll dive into that later. Executive sessions, which can be either convened separately or as part of a regular or special or even emergency meeting. And then the last one is meetings that are held for the purpose of either presenting information to the governing body to prepare the governing body for a regular or special meeting, or to allow the governing body to engage in the preliminary discussion or deliberations. These types of meetings are often called work sessions or workshop meetings. Now, there are some forms of communication between members of a governing body that do not fall under public meetings law. So the first piece is communication that is purely factual or education in nature, and it conveys no deliberation or decision that might reasonably come before a governing body. Now, when I provide this training to a group of folks, and there might be a quorum present for a city council or a water district, this is just information for them. So public meetings law would not apply to my training. However, because you folks all have jurisdiction over public meetings law, this training isn't just informational for you because it does impact the decisions and deliberations that you will have. So my example is not true for you as it is usually for everyone else. Other types that do not apply to public meetings law is communication that's not related to any matter that at any time could reasonably be foreseen to come before the governing body for deliberations or decisions. And this is where social gatherings fall under. So if a city council wanted to get together to celebrate someone's birthday, as long as they're just there in celebration, that is unrelated to any of their deliberations or decisions. And the last one is anything that's non-substantive in nature. So if you're having conversations about when to hold, like who's going to be at which meeting, who can't make the meeting, Becky sends you a message, what would you like for lunch? And someone accidentally replies all with their lunch order. Those types of conversations public meetings law does not apply to. They are non-substantive in nature. The law further goes into some exceptions to public meetings law. And the first is any on-site inspection of any project or program. So the example we have is a school board who visits an alternative high school in another district to get a tour of the facilities and learn more about the program. This could fall within this exception. Now, if during that tour, the school board members began discussing their budget or programs at their school, then that would need to be cut in order to make room in the budget for programs that they are viewing, for example. Then we would start to be moving into the realm of conversations for delivery that are subject to deliberation and decision. So the on-site inspection exception would no longer apply. The next is attendance of members of a governing body in a national, regional, or state association to which the public body or the members belong. So this looks like the Oregon School Board Association Conference, League of Oregon Cities Conference, the Special Districts Association of Oregon, or the Association of Oregon Counties. I could go on. There's a lot of associations that our governing body members are members of and attend these gatherings. And again, it is just important to note that if a quorum is participating in these gatherings, that they are not still must not talk about topics that may come before the governing body for consideration. Okay, so back to our initial question, when do we need to hold a public meeting? We need to hold a public meeting when a quorum of a governing body, of a public body, convenes in order to make a decision or to deliberate towards a decision on any matter. That is when we have a meeting. And the Oregon form of government requires an informed public, aware of the deliberations and the decisions of governing bodies and the information upon which these decisions were made. So this means that any meetings held by governing bodies must be open to the public, and a meeting can only be closed when there is a specific statute that allows it. The purpose of public meetings law is to make sure that governing bodies are making decisions in ways that are open and transparent. So I'm going to pause because that is the end of the definitions section, and open it up to our commissioners. There may be other folks online, but question period is just for our commissioners.
I did want to comment that Burke has joined the meeting.
Well, we did have some questions during it, so I'm going to take that as there are no additional ones, and we'll move on, but we'll have other opportunities. So there are several provisions in public meetings law that address some of the more administrative functions of a meeting, And that includes public attendance and location requirements, meeting accessibility. There we go. For some reason, Teams is not playing nicely today with the PowerPoint noticing requirements, recordings and minutes of meetings, and then the grievance process. So even though, in our case, staff is performing a lot of these functions, it is still the governing body member's responsibility to ensure that public meetings law is being followed for these pieces. You're going to hear me say this over and over and over again over the course of this training, because we really want to make sure that governing body members really understand what their individual responsibilities are. Okay, so let's start with the public attendance and meeting locations. Now, all meetings of a governing body shall be open to the public, and all persons shall be permitted to attend any meeting except as those that are specifically mentioned in the statutes. A quorum of a governing body may not meet in private for the purpose of deciding or deliberating towards a decision on any matter, except as what's otherwise permitted in public meetings law. Now, we get a lot of questions about public comment and disruptions. And it's important to note that in general, public meetings law only requires that the public be allowed to attend meetings. Public meetings law does not address whether the public is allowed to comment or testify at meetings. Now, there are other statutes and bylaws and provisions and ordinances that governing bodies may have that require them to have that public comment opportunity. But public meetings law itself does not require the ability to comment or testify. Now, we will talk about I know where you're going, just take a breath. Okay. A governing body may permit comment or testimony by its own choice or pursuant other statutes, and may have its own procedures for public participation in the meeting. It is up to the governing body and the presiding officer to maintain the decorum of the meeting, and they may limit participation accordingly. We'll talk more about public comment when we get to the minutes. We'll talk more about it in a moment. Let me just say that. So let's talk about meeting location requirements to ensure the public has access to our meetings. So no public meetings can be held in places where discrimination on the basis of race, color, creed, sex, sexual orientation, gender identity, national origin, age, or disability is practiced. In addition, it is also considered discrimination on the basis of disability for a governing body to meet in a place that's inaccessible to persons with disabilities. And more information about this can be found in the Americans with Disabilities Act of 1990 at ada.gov. It is also discrimination to make a good faith effort to have an interpreter for persons who are deaf or hard of hearing if they are requested for a regularly scheduled meeting. So the requirements are that if someone requests an interpreter, the requirements are that they need to give the governing body at least 48 hours notice of their request for the interpreter. We'll talk more about meeting notices in the next section, but this is why it's important that meeting notices go out with as much time as possible so that we are giving folks the opportunity to make this request. This request also needs to include the name of the person who's making the request and any sign language preferences or any other relevant information that the governing body may request. If the meeting is being held with less than 48 hours notice, so for example, with a special or emergency meeting, or excuse me, a special meeting, a reasonable effort shall be made to have an interpreter present, but the requirement for an interpreter does not apply to emergency meetings. Now, requests for deaf and hard of hearing services can be requested through the Oregon Department of Human Services website. And this is something that we have linked. A lot of community colleges across the state also provide interpreters. So those are just a couple examples of options for folks to access those. When a governing body needs to hold its meetings within the borders or jurisdictions, its borders or jurisdiction, its administrative headquarters or main office, or its nearest practical location. For state, county, city, or special district groups that are within land owned by a federally recognized Oregon tribe, their meetings can be held on within those territories as long as it's also within the geographical boundaries of the state. And we do have some folks that actually does apply to. For state agencies, boards, and commissions, the geographical boundaries are going to be the entire state. So our geographical boundary, the entire state. We can hold our meetings anywhere in the state. For other public bodies, we encourage them to check with their administrative staff, their charter and legal counsel. They're unsure what their geographical boundaries are. Now, what if multiple governing bodies are meeting, or if a governing body is meeting with an elected official of a federally recognized Oregon tribe? Whose jurisdiction do you meet in then? In these situations, you should meet in one of the jurisdictions or the nearest practical location. So if you've got folks meeting, from Joseph, and you've got someone from Lakeside, two opposite ends of the state, you can find somewhere to meet that's accessible in the middle. And probably Bend. Bend is always my middle go-to. In the event of an actual emergency necessitating immediate action, meetings can be held in locations other than those we've described by the law, but that is when it is an actual emergency. So things like floods, fires, weather events, the giant chasm that opened up right in front of the office, or that swallowed the building. Training sessions also can be held outside of a jurisdiction, as long as there's no deliberation towards a decision that's going to be involved. And when it comes to electronic meetings, any governing body meeting, including executive session, can be held using electronic communications or telephone. Public meetings law still applies to these meetings. And if the meeting is being held only electronically or by telephone, the governing body has to provide the public either a place to physically view it in real time, or at least one electronic means where they can listen to the meeting in real time. So this can be done by making a place available where the public can view and listen, or again, at the time it occurs, or providing them a call-in number, a link, a live video feed, etc. So in addition to this, there are some other requirements when it comes to electronic meetings, and that is an electronic access. And regardless of how the meeting is held, to the extent possible, governing bodies must provide the public access to the meeting by telephone, video, or other electronic or virtual means. So a phone number to call in or a link to view the live video feed, those would all work. For governing bodies that allow in-person or written testimony, the public must be permitted to submit oral testimony virtually. And in the case if they allow written testimony, they also need to be able to submit their written testimony electronically during the meeting. For executive sessions where the media are statutorily authorized to be present, if any person attending the executive session is attending by telephone, video, or other electronic means, the governing body shall provide members of the media the same attendance options. So this includes if any member of the governing body is attending virtually. Nothing in this subsection, though, prevents the governing body from establishing reasonable security measures to ensure the media's attendance by telephone, video, or other electronic means is conducted through a secure connection or method. And I just want to point out that that last one was an administrative rule because the statute, it looks like this, it's the statute, but it's actually the administrative rule. So now let's talk about, that kind of cues us up for another popular topic of discussion, which is media. And OGEC cannot define who is or who is not media. The Attorney General Opinion 8291 addresses this issue, and it is ultimately up to each governing body to determine if an individual meets the requirements that have been outlined in that AG opinion. The governing body can adopt an application or procedures for individuals to be recognized as media, but it doesn't mean that if a member of the media doesn't follow those procedures, that they can be denied access. So for example, we ask media to let us know ahead of time if they're going to be joining the meeting. This is just to help our meetings run more smoothly, but just because someone didn't give us the heads up doesn't mean that we can then not admit them to the meeting. If a complaint is filed regarding an individual of the media not being provided access to the meeting, OGEC is going to look at whether the governing body's decision was reasonable in light of the AG opinion. So we'll be looking at how the AG opinion criteria was applied, not whether or not they're media. I also do want to point out that the AG manual does direct folks to reach out to us for a definition on media. It's if someone qualifies as media. So any questions from our commissioners? Just cruising right along. Let's talk about noticing. So again,
excuse me. I just wanted to say something really quickly. I cannot, of course, speak for any of the other commissioners, but please don't interpret my lack of questions as disinterest. In my opinion, you're simply being very clear.
No, I thank you, Commissioner Burke. I appreciate that. I don't take it as disinterest at all. So, but I do appreciate the clarification. So let's dive into the next administrative task, one that you all have staff that help do it for you. But again, another one that the governing body members really do need to be aware of the noticing requirements. So in order for the public to be aware of the meetings, the governing body needs to issue a public notice to the general public and interested parties who have requested to receive a notice of any upcoming meetings. This includes members of the media. Now, for regular meetings, this notice needs to be issued within at least 48 hours before the notice is held. So this is one of those administrative rules that we adopted to be in alignment with the requests for interpreters, so that notices are coming out in theory with, if you are paying attention, with just enough time to request an interpreter. Yes, Commissioner Payne.
Yeah, that was my question. It seems that this doesn't actually allow enough time to request an interpreter. If you're getting notice 48 hours and then you have to request an interpreter 48 hours ahead of time, it seems like the notice should be
72 or more.
Yes, thank
Yeah.
you. It seems to create a problem here. It seems to create an issue.
I think this will be a future rule amendment.
Before the statute, if I remember right, just says a reasonable amount of time. So it does not give any amount of time, is what the statute says. But we agree. To satisfy the noticing requirements, meeting notices, and this is a big one that folks don't realize, meeting notices need to be placed in an obvious place, such as on the public body or governing body's website. It can also be placed on a publicly accessible third-party website that's linked back to the public body or governing body's website. That would also be allowed. For state agencies and educational service districts, they are required to post on the Oregon Transparency website. This website is also open to any public bodies, so any public bodies can post their meetings there. So we do let folks know about that opportunity. Other places that bodies can post their notices include newspaper notices, community or bulletin boards, social media accounts, email, and mail. Now, if they don't have a website, some of the smaller, road districts and things don't necessarily have a public body website to post on. So they could use these other means. As a best practice, we suggest that folks are consistent so that if they always post in the newspaper, they're, posting in the newspaper, not just on a social media account for this one-off meeting. So the best practice would be to be consistent. Now, the information that's required in the notice is going to be the date and time of your meeting, where the meeting is being held, both the physical location as well as any online links. A list of subjects to be considered at the meeting. So this can look like providing an agenda, or it could be a list of subjects to be considered. But by providing this, it does not limit the ability of the governing body to amend that list or add to it or remove subjects from that list at any time prior to or during the meeting, so that it can be amended at any time. Also, the name, telephone number, and email address of the person to contact at the public body to request an interpreter or communication aids needs to be on there. And for meetings that are being held for only executive sessions, there's the additional noticing requirement of the citation that identifies the specific statutory citation for that executive session, or if it's multiple statutes, list them all. Now, yes, Commissioner Payne.
Thank you. I have a question about social media being a sufficient way to post a notice to the public. It seems to me that that would require that everyone have a social media account in order to get notice. Has there been any argument from the public that they shouldn't have to have a social media account in order to get notice of public meetings?
So, yes, I think that's a valid point, which of course is why really what we're trying to do is make it as clear as possible, put it on the website if there is a website. There are very small districts, as Stephanie said, that do not have websites, do not have anything. I mean, districts that basically involve 33 people. And they have their only access to noticing is putting a bulletin on a bulletin board, and at the same time putting it on the group's Facebook page. But I think the point is correct that someone may not have Facebook that provides them with no notice. So that is sort of, the ones at the bottom are the last ditch effort, not the primary effort, and may need to be revisited.
And I do want to point out that if folks have contacted the public body and said, I am an interested person in getting those meeting notices, then the public body or governing body has to notify those interested persons. So we do that through email. So that's one, that we give our notice, but there are other ways as well. So they have the opportunity to speak up and say, Facebook, for example, I don't have access to Facebook. I need my notice in another way.
Yes, but notice to the interested persons is not notice to the public.
No.
So really what we're trying to get all of the governing bodies out there to do is, yes, give the individual notice, however you want to the people who've requested it. But separately from that, find a way to make notice to the public publicly.
Yes, definitely. So for the example, we do use our agenda because it was the easiest, and then I'm not picking on any governing body. So you will notice that it has the time at the top. It has our location, both our physical location, as well as our call-in number and a link to view it. We have a list, this cuts it off, but as you have seen our agendas before, you know it's a list of the subjects that we're going to discuss. And it also has our contact information for Becky, who is the person to contact for accessibility and accommodation requests. So it has her information there. Now, for special meetings, no special meetings can be held without at least 24 hours notice. Notice needs to be given to members of the governing body, the news media, and the general public. For emergency meetings, in the event of an actual emergency, the governing body can notice a meeting with less than 24 hours notice, but it does need to be noticed with as much time as possible. The media and interested parties still need to be contacted. The meeting notice needs to be posted in all of the usual locations. And the minutes for the meeting need to describe the emergency that justified having less than 24 hours notice for that meeting. Any other noticing questions? Great. Cruising on to recordings. So this is actually, we'll take a short bio break after this section. But again, this is another one that oftentimes has lots of staff support that the governing body members need to be aware of what the actual requirements are. So the governing body is required to provide documentation of all of its meetings in one of the following forms. So either sound, video, digital recording, or written minutes. Full transcripts are not required, but if using written minutes, they should give a true reflection of the matters discussed at the meeting and the views of the participants. All minutes or recordings should be made available to the public within a reasonable amount of time after the meeting. Now, come on, why aren't you working? So the minutes need to include the names of the governing body members who are present, any motions, proposals, resolutions, orders, ordinances, measures, and their results, the results of all votes, the vote of each member by name, unless the board has more than 25 members, the substance of any discussion, and reference to any document discussed. Now, all voting has to be done by public vote, excuse me. The use of secret ballots is not allowed. The results of all of the votes need to be recorded in the official minutes or recording. So this includes the vote of each individual governing body member by name. If written ballots are used, the ballot needs to identify the name of the governing body member. So the vote, including the member's name, needs to be announced during the meeting where the voting happens. So there needs to be an announcement so that everyone who is viewing the meeting understands how each person voted. So examples of some questions that we receive around this topic: can governing body members vote by email? And the answer is no, because again, it has to happen in open and public. Are electronic votes allowed? And the answer to that is it depends on if the voting results are visible to everyone in the room, both physically and virtually. The most common one, I would say, is for our consent agenda. Say the group all votes in favor or all votes opposed. Does that work, or do we need a roll call vote? And our response is a roll call vote is the best practice. But regardless of how they handle it, the individual votes need to be identified in the official minutes or recording, and it needs to be identified the name of each person and how they voted. So roll call does make that.
I have a question.
Yes.
I have a question. I was once on a water board with 5 members, and occasionally we would say, all those in favor say aye, aye, and if it was unanimous, we would have that in the minutes. In such a case, if it's unanimous, or is it necessary to list the names of everyone, since everyone there voted yes or no?
Great question, Commissioner Burke, and your district was not the only one that was doing that, which brings me to this slide here. So what happens if all the governing body members vote all in favor or all opposed? Ultimately, it depends on how the governing body is keeping their official records. And are they keeping written minutes, audio recordings, or video recordings? But the short answer to your question is unanimous does not work. So it does need to list each individual member's name and how they voted. So for written minutes, again, you need to record the vote of each member by name and announce the vote results. For audio minutes, there needs to be an announcement of the vote of each member by name. Susan, did you have something you wanted to add?
Yes. So a governing body could still vote and say all in favor, all opposed, etc. If they keep the written minutes, they can simply put into the minutes the vote was unanimous. Commissioners A, B, C, and D voted on.
But that's
identifying them by name in the written minutes. But if their official record is the audio or video, then in the meeting itself, they must announce the vote of each member. Yeah. Commissioner Payne?
So for the requirement in the minutes that you don't have to list each member by name if there's 25 or more members, during the meeting, do you still have to identify the vote of each member by name if there's 25 or more members?
So how that requirement works is if your governing body has 25 or more members and at least one of the members requests that they include the vote by name, you have to do the vote by name. So, and there are governing bodies that are incredibly large. Most are not, thankfully. But yes, if any one of those 25 plus people say, I want a roll call vote, you're doing a roll call vote. And you would have to list every single member. But if none of them do, then in the written minutes, you would not have to list the names.
So in the 2024 legislative session, Senate Bill 1502 was passed that required starting in 2025 that all common or union high school districts, educational service districts, community college districts, and public universities start recording their meetings and of all of their meetings, all of their governing body meetings. And that they make these available within 7 days following the meeting. They're required to either to post the video recording of the meeting to their public body's website or a social media site. If the public body lacks the broadband internet access, the public body can comply with this provision by posting an audio recording instead to either the governing body or public body's website or social media site. Now, this doesn't apply to any portion of the meeting that's been conducted in executive session. nor does it apply to school districts with less than 50 students. State agencies, state boards and commissions, as we mentioned earlier, can hold their meetings over telephone or other electronic means. For state boards and commissions that are within the executive department and whose members are subject to Senate confirmation, such as you all, there is now a requirement to electronically record your meetings. So a state board or commission that meets through telephone or other electronic means needs to record the meeting. The recording must be published on a publicly accessible website or hosting service so that the public can access it without charge. These recordings need to be posted for no less than 30 days, so no fewer than 30 days. And this also does not apply to meetings, to properly held executive sessions. So just to let you all know, we post recordings of our meetings. We do video recordings. We also have an audio as a backup. We post the audio to our website, and we post a link to the video on our website. We actually have our videos hosted in YouTube, and we keep our videos up indefinitely. So we don't right now have plans to take any of our meetings down. So this brings us to about the halfway point. I think it might be a good idea to take a quick 5-minute bio break. We have covered resources, definition, public attendance, accommodations and accessibility, noticing and recording in minutes. So when we come back, we will dive into the executive sessions and beyond. So let me look. It is 10:48. So we will come back at, let's just make it round 10:55, just to make it easy. Excellent.
Bam.
Welcome back, everyone. I know we do have some folks joining us online and over the phone that are not our commissioners. Welcome. I just want to reiterate that this training does not meet the public meetings law training requirement that is in public meetings law, and that this training is intended for our commissioners. So while we will pause periodically for questions, it is for our commissioners to ask questions, not members of the public. So now that we are back from our break, we are actually a little bit more than halfway through. And we are going to move on to executive sessions. So an executive session is any meeting or a part of a meeting of a governing body which is closed to certain persons for deliberation on specific matters. A governing body can hold a meeting consisting of only executive session, or it can do a meeting that allows it to be part of its regular public meeting. The noticing requirements are the same for both, which we already discussed and we'll discuss again. In executive session, the final decision prohibition states that no executive session may be held for the purpose of taking any final action or making any final decision, unless there's a statute that applies. So the question we often get is, can a governing body discuss how they're going to vote in executive session? And honestly, it's likely that the governing body members are going to know or be aware of how their fellow members are going to vote. And reaching a consensus in executive session is allowed. It is that final decision or the letting the public know the actual results of the vote. So that is why that final decision has to happen in open session and is not allowed in executive session. Yeah.
I just want to add, for the benefit of those who are in the public that may be watching, hopefully all our commissioners already know this. The commission has a specific statute in ORS 244-260 that requires the commission to vote in executive session on preliminary reviews. So we are an exception to the rule.
As well as own motions.
As well as on motions, correct.
So the AG manual actually has a checklist for executive sessions. We've adapted it a bit to kind of outline the steps that need to happen before a public body can meet an executive session. So before holding an executive session, the meeting has to be noticed in the same manner that you would provide a notice for a public meeting. You have to make sure the notice cites the specific statutory provision or provisions for entering the executive session. And each board member should be provided a copy of the notice so that they can independently verify that the executive session has been cited properly and that the provisions are followed once the meeting is held. A governing body can enter executive session that is part of a regular, special, or emergency public meeting or a standalone executive session. So let's take a look at this as if the executive session is part of the regular meeting for the next one. So during the public meeting, if any governing body members have a conflict of interest on an agenda item that's going to be discussed in executive session, this needs to be announced during the public meeting. So then the presiding officer needs to make an announcement in public that the governing body is having an executive session. So I just want to recognize that conflicts of interest are part of Oregon government ethics law, not Oregon public meetings law. But for many governing body members, if they have a conflict of interest, they have to make a public statement. And so that's most often going to happen during a meeting. So any declarations of conflicts of interest have to happen during a public or open session. When the presiding officer makes the announcement that to the public that the governing body is having an executive session, they need to cite the specific reasons and statutes for entering the executive session for each subject that will be discussed. If they intend on coming out of executive session to take action or vote, they need to announce when the open or public session will begin again. And they need to specify if any individuals may attend the executive session. Lastly, you want to instruct the media in any of those specified folks that are allowed to attend what may not be disclosed from the executive session. So if it's not specified, the media may report on anything. And if you happen to discuss matters other than what you've cited, the media can report on those additional items. There are times when the media can be excluded from attending an executive session, and I'll make sure to highlight those as we go through. Then during an executive session, make sure that the conversation is limited only to the topics that were cited as the reason for executive session. No final decision can be made in executive session, so you want to come back to open session to take any final action unless you have the statutory authority to make such decisions in executive session. When coming back into open session, if you did not specify the time that you did not specify a time that you would reconvene, you can just open the door and announce that you are back in open session. If you did specify a time in which you would reconvene the open session, then you would need to wait before convening that, and you came out early, you would have to actually wait until that specified time to allow the public and interested parties to attend. If you come back into open session unexpectedly after previously announcing that you would not reconvene into open session, you may be required to postpone any final decisions or final actions until another properly noticed meeting. And then after the meeting, keep minutes or sound, video, or digital recordings of all executive sessions. So the AG manual provides an example script used in convening executive session during public meetings law. We provide you all with a script for when our chair or vice chair is reading the script for us to go into executive sessions. But just to break it down a little bit, the first paragraph in this notice states the governing body's entry into executive session. It cites the statutes for going into executive session during this meeting. You do not want to list all of the provisions or just 660. You actually have to list the specific provisions that you are going to be discussing that apply to this specific meeting. The second paragraph addresses the attendees, which includes the news media and designated persons, as well as who should leave the room. Paragraph 3 provides guidance on what not to report on for the media and those that are attending. Paragraph 4 acknowledges that no final decisions will be made. And lastly, it states that when the meeting will return into open session and when the audience is welcome to rejoin. Chair Fiscum.
Thank you, Director Hefner. All I wanted to say briefly for my colleagues, especially new Commissioner Mettler, is that our staff, to its credit, along with the Department of Justice, has prepared for our use a very excellent and precise sample script, which next Friday you will hear me read in detail. And that's a good thing for us to do as an attempt, and a successful attempt to comply genuinely with the statute. You will also note that on our agendas, there are a number of executive session complaints which have arisen. So it's very important for us to use not just a sample script, but our own script, a very well done one. Thank you, Director.
Thank you, Chair. So let's talk a little bit about the permissible purposes of executive session. So it can only, executive sessions can only be held when permitted by specific provision of the law. For the most part, executive sessions provisions in 192.660 are optional, which means the governing body isn't required to hold executive session to discuss these topics. The exception would be when there are other laws such as FERPA or HIPAA or specific federal or state laws that might require confidentiality, which is the case for our preliminary reviews and own motions. We are bound by confidentiality for those two situations. So we are not allowed to do those in open session. So for us, those are not optional, but for most of these, they are optional. Some of the executive session provisions have prerequisites or other requirements that must be met before you can convene an executive session. So we'll make a point to highlight some of those. And any topics that are discussed in executive session have to be limited to those topics expressly permitted by the statutes or the provisions under which the executive session is convened. So we have to be very narrow about our conversations. So let's take a look at some of the relevant permissible reasons for convening an executive session. Now, Lex Teeny created a handout breaking down our executive session provisions, the ones that are most frequently used. It also includes the prerequisites, and we organize the provisions in the following categories. So that's how we're going to go through it today. So the first category is confidential records and litigation. The next is hiring and employment, negotiations, safety and security provisions, and then provisions that are less frequently used. So that reference is available on our handouts on our website, as well as in the materials that were provided to you for today. Now, a governing body can hold an executive session. So the first one we're going to take a look at is the confidential records and litigation. So a governing body can hold an executive session to review information or records that are exempt by law from public inspection. So to enter executive session under this provision, the information or records must be expressly exempt by law. This would include federal and state statutes on confidentiality. Information and records that are exempted are listed within public records law, which are in ORS 192 as well. And an example of a record that could be reviewed under this provision, one that not only we use, but other governing bodies use very frequently, it was reviewing attorney-client privilege documents. So you can use this provision to meet with your attorney in executive session, but there has to be that written record, such as a legal memorandum, there for you to meet in under this provision with your legal counsel. Other examples include confidential student records, test and examination materials, workers' compensation claims, investigatory materials, public records pertaining to litigation, trade secrets, and then parts of contract proposals and bids, certain aspects of them. Oh, I apologize. A little wonky. So there's one other provision that allows a governing body to enter executive session to consult with their legal counsel, so long as the attorney is included in the meeting. So this means that they can be there in person, they could be on the phone, they could be online, or other electronic means. They just need to be an active participant in the meeting. So it allows the governing body to discuss with their counsel their legal rights and duties with regards to current litigation or litigation that is likely to be filed. This exemption does not apply to litigation that has been concluded. And the Attorney General recommends that that public bodies only use this provision under the advice of their legal counsel. Ultimately, the purpose of this is to put place government bodies who are parties or potential parties to litigation on even footing with private parties. Now, I do want to mention that media is permitted to attend these sessions. The only time that media can be excluded from this is if they are party to that litigation that's being discussed, or they're an employee or an agent or a contractor of a news media organization that is party to the litigation. So let's, yes, Commissioner Payne.
So just to clarify, general legal advice to avoid litigation in the future cannot be done in executive session. There has to be a substantial likelihood of litigation regarding a specific issue for this, for that discussion to be held in executive session. Am I right?
So for it to be held under subsection H, there needs to be either current litigation or a reasonable likelihood of that litigation will be filed. But you could still hold it under subsection S if the attorney is giving confidential legal advice to the governing body.
But there has to be that written document.
Right. The attorney should create a memo or letter or something for the public body, for the governing body, but yes. So you could, it's not a absolute prohibition simply because there's no current litigation or likely litigation. It could be to avoid something moving to litigation, you need to consider this legal advice under subsection F.
So if an attorney, just to follow up, so if an attorney creates a legal memo to the body, they can discuss that legal memo in executive session. But if there is no document to discuss, like a legal memo, then they cannot have discussions with counsel in executive session unless there's likely litigation.
Arguably, that's correct. I mean, this has been a sort of ongoing discussion with DOJ in terms of, because when they added information to the subsection F language, it says information or records that are exempt by law. DOJ's interpretation of that and advice is that information is information that is included in a record that would be exempt. So that's why they are saying you would need a written memo or something. But yeah. Jim Fiskin?
Thank you, Director. If you're going to discuss this or deal with this later, so be it. My question is, how are local governments or any government agency supposed to define media representative? Do we have advice for them in that regard?
So that goes back to OGEC cannot define media, but that we would refer people to the AG opinion 8291, which outlines the criteria for being considered media and to utilize the advice of their legal counsel.
And I would simply add, under that opinion, it is the governing body at issue that must make the determination whether someone qualifies as media or not. Not staff, not us. Each governing body has to say, this person qualifies as media and would be led.
Thank you. I'll just say this one other thing for my colleagues. This is an issue that sometimes confronts us as commissioners because of, quote, social media, unquote, or other than my definition from my day of media, that an issue which will come up. So I do appreciate your answer to that question. The reference to the DOJ is a good one. Thank you.
So the next section we're going to look at is the hiring and employment provisions. So while a governing body can meet in executive session to discuss the employment of a public officer, an employee, a staff member, or individual agent, there are multiple steps that have to be taken first. The first is that the vacancy must be advertised for the position. The second is that regular hiring practices need to have been adopted. And in addition, if the employment is for a public officer, the governing body needs to provide the public with an opportunity to comment on the filling of that position. Now, this does not mean that they have to comment on the candidates. It is just the actual position, which we have clarified in an administrative rule. For chief executive officers, in addition to these things, the governing body needs to have also adopted hiring standards, criteria such as a position description, policy directives, which include agency and position goals. And these need to be adopted at a public meeting where the public has had a chance to comment. So this is before we can even meet an executive session for this topic. Susan, did you have something you wanted to add?
I was just going to point out that this is that one exception in the public meetings law. While public meetings law itself doesn't require public comment, this is the
Yes.
exception. If you're doing hiring and you're holding an executive session, you must, and it's a CEO or chief administrative officer, you must allow public comment on your hiring, on the adoption of your hiring plan.
So this provision cannot be used to discuss these, and this is addressing questions and cases that we have seen come by us in the past. So you cannot use this provision to discuss filling an elected position when it becomes empty. You cannot use this provision to fill a vacancy on any public committee, commission, or advisory group. You cannot use it to discuss the general employment policies of the public body, the agency. You cannot use it to discuss the officer's salary or benefits. And lastly, you cannot make a final decision about a candidate. That is not allowed in executive session. The governing body must return to a public meeting before taking that final action. Now, a governing body can also hold an executive session to consider the dismissal or disciplining of a public officer, employee, staff member, or individual agent, and may hear complaints or charges brought against such persons. However, the governing body is required to provide a written notice to the affected individual within 24 hours before the executive session, so that the individual can request an open hearing. Now, when we talk about open hearings in the context of executive session, we're talking about a public session. And we're going to talk about what needs to be included in the notice in a minute. Written notice required. I apologize. For some reason, the clicks are all off today. So a governing body may also convene an executive session to review and to evaluate a job performance of a chief executive officer, other officers, employees, and staff. However, just like with the discipline dismissal provisions, this only applies if the individuals whose performance is being reviewed and evaluated has not requested that open hearing. So let's take a look at the written notice requirements. In order to provide the individual with a meaningful opportunity to request an open hearing, the governing body is required to provide them with a written notice of the executive session before the meeting. The written notice must be provided at least 24 hours or 1 business day in advance and needs to include the identification of the governing body before which the matter is going to be considered, the time, date, and location of the meeting, the purpose for which the governing body proposes to convene the executive session, and information on how that individual public official may request an open hearing. Now, while these provisions require an open hearing if the person requests, we do not construe this provision to require an adversarial hearing, but just an open or public session. The affected person does not need to be present and has no right to postpone the hearing to permit an attorney to attend or to have a formal hearing unless another law, contract, or collective bargaining agreement provides those rights. So we use this one, or we use the provision to review our executive director in executive session. Every year you conduct an annual review of our executive director. Even though Susan knows that this is on the calendar, she has approved the agenda before it goes out to you all, she still needs to be provided with notice. So we get this question a lot. well, so-and-so was involved in the making of the agenda. Do we still have to provide them with notice? Absolutely, yes. Still have to provide them with that written notice. So again, public meetings law makes it very clear that for the hiring and employment provisions in A, B, and I, sub A, sub B, sub I, they cannot be used for the following discussions. They cannot be used to conduct general evaluations of an agency goal, objective, or operation, or any directive to personnel concerning agency goals, operations, or objectives. And again, no compensation, discussions around compensation, including salary and benefits, can be discussed during these executive sessions. So there are 4 provisions related to negotiations, labor negotiations, real property transactions, trade and commerce negotiations. So that's what we're going to look at next. A governing body can hold an executive session with their designated labor negotiator to conduct deliberations with the person that's been designated by the governing body to carry on those labor negotiations. This subsection also allows the governing body to request members of the media to leave. Now, the other labor consultation provision allows or states that labor consultations are to be conducted in an open meeting unless negotiators for both parties have requested an executive session. And then they can be conducted, those negotiations can be conducted in executive session. Under this provision, they are not subject to the notification requirements listed within public meetings law. For real property transactions, a governing body can convene an executive session to discuss the negotiation of real property transactions with individuals that the governing body has designated for the purpose of negotiating those real property transactions on behalf of the public body or governing body. So note that this provision does allow the governing body to discuss the negotiations with the person that they've designated to conduct the actual negotiations. Real property transactions are not limited to the sale or purchase of real property. It could include negotiations regarding long-term lease transactions, for example. This provision, though, does not include the discussion of a public body's long-term space needs, nor does it include the general policies concerning lease sites, for example. The executive session must be limited to the discussions of negotiations regarding specific real property. And while the governing body can come to consensus about whether to accept an offer, they are still required to conduct a vote in a public meeting. The next one is trade negotiations, which this provision allows the preliminary negotiations involving matters of trade or commerce to be conducted in an executive session when the governing body is competing with other governing bodies in other states or other nations. So the use of this provision is permissible when the governing body knows or has good reason to believe that they're in competition with those other governing bodies or nations regarding the matter to be discussed. But I want to point out that this provision does not apply when the governing body is in negotiation or competition with other governing bodies in Oregon. So for example, if 2 cities are in competition, and neighboring cities were in competition, this would not apply. The next section goes over safety and security and has some new provisions. This one is not new. So this one allows school boards to consider matters relating to school safety or plans to respond to safety threats made towards school. There is also governing bodies can meet in executive session to review programs that relate to the security of any of the following topics. So nuclear powered thermal plants and nuclear installations. The radioactive material transportation. So if the material is being transferred either to or from a nuclear fueled thermal power plant or nuclear installation. This slide tries to trip me up every time. The generation, storage, or transferring of electricity, hazardous substances, gas, petroleum products, sewage, and water. And in addition, executive sessions can be held to discuss the security programs of telecommunication systems, including cellular, wireless, or radio systems, as well as data transmissions by whatever means are provided. So this mostly would apply to like our utilities, some special districts, utility districts, some special districts, but in some cases, some cities or counties even, or even state agencies. The next is this one is a new one, which is to consider matters relating to cybersecurity infrastructure and responses to cybersecurity threats. And the next one also is new, and this is to consider matters relating to the safety of the governing body and the security of the public body facilities and meeting spaces. So this is limited to the discussion of the safety of the governing body, its staff, and its volunteers, and the security of the public body's facility and meeting spaces. So we didn't include all of the, well, I did actually include all the provisions. Normally, I don't include all the provisions. We try to pick the most applicable to the group that we're providing the training to. But because you all oversee other governing bodies who may be in these provisions, I have included some of the more less frequently used ones. So for public hospitals that are licensed according to ORS 441.015 to 441.119, 441.993, executive sessions can be used to discuss matters relating to the function of medical staff. So that includes all clinical committees, executive credentials, utilization review, peer review committees, and all other matters relating to medical competency in the hospital. Another one that is less frequently used is an executive session may be called to carry on the negotiations under ORS Chapter 293 of the Administration of Public Funds. These negotiations can be with private persons or businesses, and these negotiations must be regarding the proposed acquisition, exchange, or liquidation of public investments. This is a counterpart to the exemption from disclosure of public records relating to proposed investments of state funds. However, the authority to negotiate with private parties in executive session does not permit the governing body to take final action or to make a final decision in executive session, as I've said before. As I also stated before, all final decisions need to be made in open session. So a health professional regulatory board can meet in executive session to consider information obtained as part of an investigation of a licensee or applicant conduct. And the state landscape architect board and advisory committees to the board can meet in executive session to consider information obtained as part of an investigation of a registrant or an applicant conduct. So we've already highlighted some of these for you folks, but for you commissioners, but I do just want to point out the common executive session provisions that we use. So most often we use 192.660 sub 2 sub F, which is the information or records that are exempt by law from public inspection. So we use this for preliminary reviews. And the ORSs that I have indicated for ethics cases, you'll see that's what gives us the authority to present preliminary reviews to the commission. So those are what have been identified there for each different area of the law. For own motions, we also use information or records that are exempt by law from public inspection. And again, we've indicated where we have own motion authority. I do want to point out that for public meetings law, we only have own motion authority for executive session cases. We do not have own motion authority for all of public meetings law. We also use sub F to consult with our legal attorney as well when we have a legal memorandum. So it's a written document. As I mentioned earlier, we do use sub 2, sub I for the annual executive director performance review. And we also occasionally use sub 2, sub H to consult with our legal counsel on current litigation or litigation likely to be filed. So this is what you'll most often find. These are the executive session provisions you will most often find in your agendas and the why. Susan, did you have anything? Okay, just want to make sure. Now, to follow up on yes, Commissioner Payne.
So sometimes during executive session, I mean, our legal counsel sitting right there and we'll ask questions of our legal counsel. Is that problematic if we don't have a legal memoranda ahead of time from our legal counsel?
Good question because of the whole sub F, sub H thing. I'm going to follow up on that.
I mean, I find it very helpful during our executive sessions to sometimes ask questions of our legal counsel, but I also want to comply with executive session laws, so it would be helpful to get an answer on that.
Mm-hmm.
Right. And part of the dilemma, of course, is that all of it is the station-specific statute saying that all of the information or discussion relating to PRs and no motions must take place in an executive session. And so I will provide further response specific to the question of you need to have the legal memo in that particular situation.
It's a great question.
Thank you.
So as I mentioned before, members of the news media are generally allowed to attend executive session. They can be asked to leave the room for a couple different reasons. They can be asked to leave the room when the governing body is conferring with their labor negotiator. They can be asked to leave the room when the governing body is discussing the expulsion of an elementary or secondary student. Along similar lines, when the governing body is discussing students' confidential records. And then members of the media who are party to litigation or an employee, agent, contractor of the news media organization that's party to the litigation. In those situations, that is when the media can be asked to leave executive sessions. This is the handout that, it went too quick, sorry. This is the handout that Lex helped put together. And it is, like I said, focuses on the most frequently used provisions, but is really a great resource for governing bodies because it does highlight some of the OAR as well as those specific things they need to do before they can enter executive session if there's a prerequisite. So again, on our website as well as included in your information for this meeting today. So we have two examples of what happens when you're in executive session and things don't go according to plan. And to kind of help governing body members problem solve when they're in the moment, because we get these questions a lot. So the first example is that your governing body has entered executive session, and now the conversation has moved on beyond the scope of what was cited as the reason to hold that meeting in executive session. So as I've mentioned earlier, governing bodies may not discuss topics in executive session other than those that were specified in ORS 192.660 or other state laws that permit the executive session, even if the additional topics are related to the issue at hand for the reason they convened that executive session. So what do you do when the conversations go outside the provisions that have been cited? So a governing body member that's in executive session, if they realize that the topic is being discussed is one that is unauthorized or exceeds the scope, the first thing they should do is they should state their objection to the discussion. So as option one, step one, state your objection to the discussion. So state that the discussion is either unauthorized or is beyond the scope. If that conversation continues to be outside the executive session provision, then what do you do? So say your governing body doesn't get back on track even after you've announced your objection. Well, then you want to announce on the record that you're leaving the session. And then you want to actually leave the session. And for some folks, this can feel very counterintuitive. If they feel their governing body isn't doing the right thing, leaving the meeting can feel kind of wrong. But the reality is that when we have these cases brought before us, you all, our commissioners, are asked to look at the facts for each individual governing body member. And if a governing body member does not want to be held responsible for the conversation going off topic, then this is the course that they need to take. The next situation, and again, this is one of those moments of, I hesitate to bring up ethics law, but for our governing body members, it's very relevant during public meetings law. So this is a situation where you're in the middle of executive session and you realize, oh, wait, I actually have a conflict of interest, whether that be an actual or a potential conflict of interest. What do you do? Because you haven't announced it publicly, which is what's required. So the first thing you want to do is stop the meeting, and you need to let your colleagues know that you have a conflict of interest and you have not declared it. And then there are two options. You can leave the meeting before there's any discussion. So whether that be virtually or physically, but leave the meeting before there's any discussion. The other option would be to table the agenda item for a future meeting. So would be a good idea for folks to have a policy on how best to handle that moment, so that they know how to move forward as a governing body. But those are the options to avoid being in violation of ethics law. Any additional questions on the executive session provisions? Yes, Commissioner Payne.
Can they just leave the meeting for that portion of the discussion and come back, or do they need to just leave the meeting, period, for the remainder of the meeting?
They only need to leave for that discussion, and then they can come back.
Thank you.
In your case, you would have to leave them if you were on, because you're online and because we're using Teams, you would have to leave the meeting completely and then rejoin, and we'd let you sit in the waiting room until the conversation, we had moved on to the next agenda item, and then we'd let you back in, just for a technical conversation. Chair Fiscum.
I was going to ask a question, but I think I already know the answer. It would not be possible for the public body to adjourn the executive session, go back into public session to allow the conflict of interest declaration, and then go back into executive session. That would violate all kinds of notice requirements, I'm presuming.
It would depend on how you went into executive session. Like if you had done so in a way that said you would be not, that you were going to reopen a public session within the next few hours or whatever it was. If you had set a specific time, no, because you still have that issue of letting the public know that you're likely to come back into public. So it's possible. It's probably not best practice.
Thank you. That's sort of what I gleaned before I asked the questions. I appreciate it.
Chris. Okay, so let's talk a little bit about the grievance and complaint process. Because this is, and this is new for for all of us, as well as the governing bodies. So as part of us getting jurisdiction over public meetings law, a new grievance process was put into place before complaints can be filed with OGEC alleging a violation of public meetings law has occurred. So, I just want to point out that when we're talking about grievances, that is when we're talking about what is being filed with the public body or the governing public body of the governing body at issue. And when we're talking about complaints, we're talking about what's being filed with our agency, OGEC. Now, you will notice that through the whole training, we've talked about governing bodies, governing body members, and all of a sudden we're talking about public bodies. And that is because the law, the language in the statutes for the grievance process identify the public body. And that is who grievances need to be with, is the public body. So I just want to make sure that that is very clear for folks. And with all of this comes some requirements for public bodies. So the public body has to let the public know when, where, how, and to whom grievances can be filed with the public body. So a public body needs to post to their website the person and the contact information to whom a grievance may be submitted and the regular business hours during which in-person grievances will be accepted. In the absence of a designated person, a grievance may be submitted to the public body's chief administrative officer or to the chair of the governing body. If the public body does not have a website, they need to provide notice to who is the contact person in the same manner that they provide notice to their public meetings. Public bodies are required to accept grievances that are filed in person during business hours, by first-class mail, by email, and any other ways it deems appropriate. So grievances do have to be submitted in writing. So that is something to keep in mind. Now, we're going to take a look at the grievance filing process, and we're going to do that first from the point of view of someone believing that a violation has occurred, and then we'll look at it from the viewpoint of the public body. So before folks can file a complaint with OGEC alleging that there was a violation of public meetings law, they are required to file the grievance with the public body at issue first. So they have to submit a written grievance to the public body stating the facts and circumstances of the alleged violation. This written grievance must be submitted to the public body within 30 days of the date of the when the alleged violation occurred. And they have to give the public body 21 days to respond. And when we're talking about 30 days, 21 days, talking about actual calendar days, not business days. So once they've submitted their written grievance, now the public body is up. So the public body must provide the response within 21 days. Like, that's kind of obvious now. The response must acknowledge the receipt of the grievance. And when they send the response, the public body sends a response, they need to send a copy of their response to OGEC at the same time. So we have an email set up for this. It's called PBGR, for Public Body Grievance Response at ogec.oregon.gov, because we love a great acronym in state work, right? So this is so that if someone decides to then later on file a complaint with OGEC and they say, well, we never received a response, we have documentation from the public body about whether or not they did respond and how they responded. So the public body has kind of three options in their responses. So we're going to take a little bit closer look at each response. Yes, Shanoa.
I'm looking back at the requirements for written minutes, and I think this has been raised by a few of the individual public body people who have been before our body, who have had complaints against them, that they have said that the minutes of meetings have not been up within 30 days, and therefore they could not file a grievance within this 30-day timeline. And I'm wondering whether that is an ongoing issue, because it looks like that the recordings or written minutes of public meetings and executive sessions only have to be put up within a reasonable time. And so if this grievance has to be filed within 30 days, is there any sort of grace period for, or when does that start to tick, like from the meeting or from when the minutes go up? I'm just wondering if there's any, how we determine that, because it seems like if they can't know when a violation begins until the minutes are up, if that's an ongoing issue.
I would say yes, it is an ongoing issue. What the law requires is this. We've had executive sessions since 1993, but the grievance process that happened with House Bill 2805 changed it a bit and put in this process. And there is no, under the current law, there is no grace period for finding out what happened or when did the minutes get posted. But what the law requires is that the grievance be filed within 30 days of when the alleged violation occurred. So that would be within 30 days of the executive session. This isn't really part of our training here, but I will let you know there is a bill currently before the legislature. It's not our bill. There is a bill currently before the legislature to change it for the executive session grievance process to 1 year instead of 30 days.
Yes, great question. So let's take a look at the public body's response options. The first is the public body can deny the facts and circumstances that were alleged in the grievance, and then they'll need to describe the public body's version of those facts and circumstances and explain why it does not violate public meetings law. So that's option one. The second one is you can admit, the public body can admit that the facts and circumstances that were alleged in the agreements did in fact happen. That is what happened, but still deny that those facts violate public meetings law. And then the last option is option 3 is to admit the facts and circumstances that were alleged in the agreement. So yes, as what is you presented to us, that is what happened, and agree that those facts and circumstances violate public meetings law. And then this is where I think it gets interesting. Public body needs to explain the steps it's going to take to cure the violation. And so there's a couple different options. The first is they can rescind a decision that was the decision taken by the governing body that violated public meetings law. And then they can, so that is an option. They can hold a public meeting within 45 days of the original decision and acknowledge that, yes, their original decision violated public meetings law. However, good cause exists for them not to rescind that decision. But then they need to also follow up with how the governing body's practices are going to be modified to ensure future violations don't occur. Other examples that that could happen is in the case of a serial communication, they could hold a meeting where they sit and they read out loud the emails that went back and forth, for example. I know, Susan, you had some other good ones off the top of your head.
Yeah, case long before we got public meetings law, but it was an executive session violation case where they had gone into executive session to do a performance evaluation of the administrator. And in the course of much of that evaluation, they began discussing salary and compensation. And after the meeting was over, they're like, uh-oh, we did that wrong. And so how they fixed it even before it came before the commission was they scheduled a public meeting and did it all over in public.
So, regardless, and it's so important that folks know that governing body members know this, regardless of how the public body responds, once the grievance process has been completed, the person who's filed the grievance can decide whether or not they're going to file a complaint with OGEC. So it is completely up to that individual whether or not they move forward. So after that 21-day period is over, they can choose to file a complaint with OGEC. If they do choose to file a complaint, then they have to include the information from their written grievance. So they have to provide a copy of the written grievance they provided to the public body. And if they received a response from the public body, they're also supposed to provide a copy of that response that they received. If someone fails to satisfy these mandatory prerequisites before filing their complaints are going to be dismissed. So this is when you see all of those items on the consent calendar in executive session. Those are all complaints that we have received that haven't met the grievance process prerequisites. And so you are administratively dismissing those in executive session. Now, we can only accept, as you are aware, signed complaints. For public meetings law cases, we're going to open a case against each member of the governing body in preliminary review, not the staff, governing body members. The cases are going to be consolidated at the preliminary review phase and the investigation phase, unless one or more members of the governing body object to that consolidation. So they can request to be heard separately. At the conclusion of either the preliminary review or the investigation phase, the commission will make an individual determination regarding the case of each member of the governing body. Only our commission, our governing body, can determine if a violation has occurred and will also determine what the sanctions for any violations can be. For public meetings law violations, the maximum violation is $1,000 for a civil penalty. As I mentioned before, OGEC's highest priority is education. So the commission highly emphasizes issuing letters of education or requirements for additional training for violations. But it is important for folks to know what the potential civil penalty is for each violation, what the maximum is. And again, before we ever get to this phase, we really strongly emphasize that folks reach out to us for advice and guidance on how to move forward. So with the creation of giving OGEC jurisdiction over public meetings law, this did not, and the grievance process, this did not take away folks' right to pursue a lawsuit against members of a governing body. So this was already in the statutes, and this is very separate from our process. So a person affected by decision of a governing body can file a suit in circuit court. The circuit court suit has to be filed within 60 days of the alleged violation. And with suits filed under ORS 192-680, the court can actually void the governing body's decisions or actions, which is something that our governing body you all can't do. You cannot void other governing bodies' actions or decisions. Now, the court can award, if the court determines there was intentional disregard of the law or willful misconduct by the governing body, the court may award a successful plaintiff attorney payment of fees by the governing body or its public body. And the governing body members may be jointly liable for to the governing body or public body for the amount paid by the body. So it's important for folks to also understand that. Now, when it comes to the training requirement, the other addition to all of the changes that came out of the 2023 legislation is that every member of a governing body of a public body with total expenditures for a fiscal year of $1 million or more shall attend or view a training prepared at least once during the member's term of office. So OGEC, we can provide the training, or we can approve other entities to provide a training. We have a process for that. A person serving on multiple governing bodies may attend one single training to satisfy the requirements as long as their terms of office overlap and they're taking the training in that overlap. And that ultimately all members of governing bodies are encouraged to attend, even if not required. Now, the training requirement does not apply to governing body members of state agencies. And the other thing to note is that, for example, with this this expenditure piece, if for say a city council that has a planning commission. The planning commission itself would also be a governing body. And so we'd have to see, does the planning commission oversee expenditures of more than $1 million in a fiscal calendar or fiscal year? And if so, then the planning commissioners would be required to take the training. But if the planning commission itself was not responsible for those expenditures, then they would not be required to take the training. The city council would. So there is a lot of questions around, do we have to take the training? Which of our governing bodies have to take the training? So a lot of questions around that. Whew. So we have covered all of the topics in public meetings law. Look at us go. I just want to pause for a minute. We can answer any additional questions you all have.
And it is exactly 12 p.m. Excellent job, Stephanie.
Thank you. I love it when a plan comes together.
Go ahead.
Oh, thank you all for being here. Just a couple quick comments as we close, and thank you for meeting the schedule of closing at noon for a variety of reasons. I'm going to thank our directors, Myers, Mason, Hefner, Fenstermaker, for joining us today in Salem. Thank you all for being here, and thank you, Director Hefner, for the precision of your remarks. It's very helpful. Thank you to the commissioners for devoting your Saturday portion of your Saturday to this. And we will see each other next Friday, March 7th, for a very long agenda. So I would encourage you to read all the documents you'll get in writing and online in preparation for that meeting. And Commissioner Mettler will see you on next Friday and have you introduce yourself more completely to us. Director Myers, any final comments?
No, I think you have it covered, and I look forward to seeing you all on next Friday.
Thank you all again. We'll see you in a little less than a week. Thank you very much. A little less than a week. Thank you. Have a good day. Bye-bye.
Thank you all.
Thank you. Bye-bye.
Bye, everybody.
Everyone. In meeting.